All right, everyone. Thanks for tuning in. Again, my name is AJ Richmond. I am a Title IX lawyer here in Georgia. And what I want to talk about today is a decision called Victims' Rights Center or Victim Rights Law Center versus Cardona. And what's happening is the 2020 policy and the 2020 student rights were enacted during Trump, and it's now being changed for President Biden. We were expecting to receive the new rules of the new policies earlier this year. Obviously, we haven't, and we're going about halfway through 2024, and there is some idea that those are coming out very soon. But in particular, I am dealing or about to deal with a Title IX hearing, a full hearing. So we've done all of the investigation process, and now we're at the school. And we were just notified that this particular school in Georgia will use the ruling from Victims' Rights Center, Victim Rights Law Center versus Cardona against us. So let's go back to August 2024 to figure out what that actually was and how it will affect cases from that point forward to and including today, unless, of course, the Biden rules come out and change it, which I don't think they will. So this is a letter from the United States Department of Education Office for Civil Rights, and this is the organization that deals specifically with Title IX cases. This is sort of the top where the rules come from, and every school will impose it. Dear students, educators, and other stakeholders, and I can guarantee you no student I have ever represented or any student in college that is currently in college has ever actually received this letter. But needless to say, Assistant Secretary Goldberg believes that that's true. I write with an important update regarding the Department of Education's regulations implementing Title IX of the Education Amendments of 1972 as amended in 2020. On July 28, 2021, a federal district court in Massachusetts issued its decision in Victims' Rights Law Center et al. Versus Cardona. This is, of course, the case site. This case was brought by several organizations and individuals challenging the 2020 amendments to the Title IX regulations. This is important because some of these individuals were not the accused students. They were not the respondents. They were the complainants, and they were upset that either sometimes what we call hearsay was being admitted, and the hearing officers were saying, well, you can't have hearsay, so I'm not going to consider it. And how this is sort of brought about is this. Just stepping back a minute. Let's say you're a sophomore or a junior or even a senior, and a Title IX complaint gets brought against you. All of the witnesses in the case now have graduated, and your case still is pending with you in school. The old rules basically said, well, unless the people that gave statements against you, or unless they come in and actually testify at a hearing, we won't use their statements. Meaning they have to come testify. If they come testify, then we'll use their statements. If they don't come testify, then the statements are out. That was the rule. The brilliant scholars in the Cardona opinion changed that. This letter says, the court upheld most of the provisions in the 2020 amendments that the plaintiffs challenged, but it found that one part of the Code of Federal Regulations, the live hearing requirement for the Title IX grievance process at post-secondary institutions only, to be arbitrary and capricious, vacated that part of the provision and remanded it to the department, to these people. Okay? In English, the court, in this case, looked at some of the provisions, including the one I just told you about, which is whether or not people that don't go to school or that aren't going to testify at the hearing, whether or not those statements are still admissible against the accused student. In a subsequent order issued on August 10th, 2021, the court clarified that its decision applied nationwide, meaning this occurred in Massachusetts, but now it's going to apply in Georgia or Texas or Florida, wherever it is your school is. The court vacated that part of that particular provision that prohibits a decision maker from relying on statements that are not subject to cross-examination during the live hearing. The court vacated that part. If a party or a witness does not submit to cross-examination at the live hearing, the decision maker must not rely on any statement of the party or witness in reaching a determination regarding responsibility. The court now has gotten rid of this, or I should say the department has gotten rid of this. Okay? We're about to see how that plays out in real time. But now, students that gave statements that do not appear in person at the hearing, those statements can now be used against you as the accused students. So, for example, I saw John touch Sally. Saw with my own eyes. I no longer will appear at the hearing. The judge, the hearing officer, can now still use what I saw, what I said I saw, even though I'm not there to testify. Please note that all other provisions of the 2020 amendments, including all other parts of that law, remain in effect. Meaning all the stuff that helps accused students, all the stuff that gives accused students somewhat or so-called due process, that's still there. Except the part that pretty much hearsay is admissible. The affected provision is only applicable to post-secondary institutions, colleges, and does not apply to elementary or secondary schools, which are not required to provide for a live hearing with cross-examination. So at the very essence of this, it's saying the students that have the most to lose, those going to be kicked out of college, those to be kicked out of medical school, out of law school, out of graduate school, the department, our government, believes that those students don't deserve as much due process as elementary school. Those students are entitled to a hearing, but there really doesn't have to have any evidence or anybody come to testify at that hearing against them. Those students can lose jobs, can lose careers, but hey, it's okay. We want to protect victims. We want to protect witnesses. We don't want you or your advisor to be able to cross-examine witnesses. It goes on, in accordance with the court's order, the department will immediately cease enforcement of the part of the statute regarding the prohibition against statements and not subject to cross-examination. We no longer care. You don't need to do anything that requires those people to come to the hearing. We're just going to consider it. Post-secondary institutions are no longer subject to this portion of the provision. Again, college students, we just don't care. In practical terms, meaning in English, a decision maker at the post-secondary institution may now consider statements made by the parties or witnesses that are otherwise permitted under the regulations, even if those parties or witnesses do not participate in cross-examination at the live hearing, in reaching a determination regarding the responsibility of a Title IX process. The Department of Education is telling the person, the judge, the hearing officer, we don't care if the students don't show up. As long as their statement was given under some type of, investigatory process, it's admissible. For example, a decision maker may now consider statements made by the parties and witnesses during an investigation, emails, text exchanges between the parties leading up to the alleged sexual harassment, and the statements about the alleged sexual harassment that satisfy the regulations rules, regardless if they submit to cross-examination at a live hearing. A decision maker at a post-secondary institution may also consider police reports. Who the heck knows what's in those? Other than the officer's statements, what if there's other statements? Third-party hearsay. Hearsay upon hearsay upon hearsay. I heard John tell Sally tell Jane. We're going to admit sexual assault nurse examination documents. What's in those documents? Other statements made by the victim, whether or not they corroborate or impeach, you can hear them. Medical reports or other documents, even if those documents contain statements of a party or witness who is not cross-examined at a hearing. At this point, you have to be saying, how on earth is this possible? The Office of Civil Rights is in the process of identifying all documents on our website that discuss this provision and will make updates as appropriate in the coming weeks. Meaning they want to get this out there to all schools, to all students, educators, and stakeholders, and make sure it's well known that hearsay is now admissible. That you don't need to cross-examine anyone anymore at a hearing. And then, of course, it goes on and it gives you wonderful question and answers. So the bottom line is this. Ms. Goldberg doesn't care for respondents. The United States Department of Education does not care about respondents. They don't care about people that are accused of alleged sexual assault. They believe that every statement given under any circumstance is reliable and that the student making it doesn't need to be cross-examined. They believe that every statement made in a Title IX investigation is truthful and that that particular witness doesn't need to be cross-examined. This is insane. This is nonsense. This is crazy. And what's crazy is that a decision in Massachusetts, in a particular part of the country, can lead to a decision where all 50 states have to follow. I know Texas already started it, but I anticipate this will be fixed in the 2024 revisions, we hope. But I also anticipate that this ultimately will be appealed to the United States Supreme Court as a failure to give due process rights to individuals that are going to be losing their property interest in college, their contractual interest in college, and all of their due process simply because one person is saying that he or she did something, which may or may not be true. But a hearing advisor or a judge now doesn't have to worry about calling a single witness to the hearing. They can simply read the investigation report and rule on that evidence. It's just not fair. If you have any questions, comment down below. Certainly you can ask me anything you want involving this decision, and we'll have more once we hear when Cardona will be appealed. Thanks for tuning in.